Welcome to the VS Criminal Defense Attorneys podcast, providing an informative resource on criminal law with a specific focus on sex crimes. From protecting yourself from false accusations to understanding the exact boundaries of the law, being informed is always the best first line of defense. This podcast series is reviewed and approved by attorney Michelle Villanueva-Scura.
In this episode, we'll discuss the growing problem of misrepresented age on dating platforms. At VS Criminal Defense Attorneys, our Phoenix-based criminal defense team has observed a troubling pattern emerging throughout Arizona. A number of clients have been faced with serious criminal charges after encounters via dating apps with persons who misrepresented their true age. What appears to be a valid relationship between consenting adults can easily become a life-altering criminal case when the truth about the age of a minor is exposed. First, let's understand how dating apps lead to serious sex crimes charges in Arizona. The pattern is distressingly consistent across Arizona. An adult creates a dating profile on Tinder, Bumble, or similar platforms, matches with someone whose profile explicitly states they are over 18 years of age, and initiates a relationship. Only later, sometimes after intimate contact has occurred, does the adult discover their partner is actually under 18 years old. At this point, the law of Arizona has already been violated, and the adult is liable to be prosecuted despite being deliberately misled. Arizona courts have very few legal defenses available under such a scenario, so immediate legal representation becomes essential. Now, let's review what you need to know about Arizona's strict minor protection laws. Arizona has some of the most stringent laws in the United States protecting minors from sexual exploitation. Maricopa County prosecutors and those throughout Arizona have extensive discretion in charging individuals under multiple Arizona revised statutes, ARS, when sexual misconduct involving minors is alleged. Here are some key sexual offense statutes involving minors in Arizona. ARS Section 13-1405, Sexual Conduct with a Minor. This statute criminalizes sexual intercourse or oral sexual contact with any person who is under 18 years of age. Classification: Class 2 felony, if the minor is under 15, and Class 6 felony, if the minor is at least 15. Potential penalties: substantial prison time and lifetime sex offender registration. ARS Section 1335-0601, furnishing harmful items to minors, sending explicit or obscene materials to a minor, such as messages, images, or videos, is illegal. Classification: Class 4 felony. Important note: these charges can stem from digital communications that occurred before knowledge of the minor's age. ARS Section 132929, unlawful luring of a minor for sexual exploitation. Communicating with a minor with the intent of engaging in sexual activity is prohibited. Classification: Class 3 felony. Evidence considerations: even suggestive or flirtatious messages could be used as evidence. ARS Section 131404, sexual abuse. Touching the intimate parts of a minor carries serious legal consequences. Classification: Class 3 felony if the minor is under 15, and Class 5 felony if the minor is 15 to 17, unless there is consent. Defense challenges: consent may be a limited defense in some circumstances. ARS Section 1335-53, sexual exploitation of a minor. Possession, distribution, or solicitation of explicit images or videos of a minor is illegal. Classification: Class 2 felony with significant penalties. Digital evidence can include images received through dating apps or messaging services. Here are some additional critical Arizona statutes. ARS Section 131430, child enticement. ARS Section 133560, aggravated luring a minor for sexual exploitation. ARS Section 131410, molestation of a child. ARS Section 131407, defenses. Critically, Arizona law provides limited defenses in these cases. ARS Section 131407b states that it is a defense if the defendant was not aware of the age of the minor and such person could not reasonably have known the age of the minor. However, this defense is extraordinarily difficult to assert successfully. Arizona courts have set a very high bar for what constitutes reasonable inability to know a minor's age. Simply being told by the minor that they are over 18, or seeing an online dating profile stating an adult age, is rarely sufficient in practice, and judges and juries typically have little sympathy for these claims. ARS Section 131407E, Romeo and Juliet exception, provides a defense if the minor was 15, 16, or 17 years of age. The defendant was under 19 years of age or attending high school and is no more than 24 months older than the minor, and the conduct was consensual. Let's now take a look at the legal reality. What many of our clients find surprising is that false representation of a child's age is typically not a valid defense in Arizona law. The law typically imposes a strict liability requirement for child-related sex crimes. That is, the prosecution does not need to prove the defendant knew the person was a child. The presumption that you were communicating with an adult, even when deliberately duped by incorrect data or phony profiles, typically does not provide much legal protection. This allows for a troubling legal climate in which individuals can face severe punishments even when attempting in good faith to communicate solely with adults. You might be wondering about the potential consequences. The consequences of conviction are serious and life-changing and include long prison terms, sex offender registration, irreversible harm to reputation and future career opportunities, restrictions on where one can reside and work, restrictions on internet access, and continuing probation or parole supervision. Here are some preventative measures to take into account. Though there is no foolproof strategy, our experience recommends the following protective steps. Request and verify government ID when meeting someone from a dating website, especially if there is any doubt as to age. Consider limiting dating app matches to individuals 21 and older, offering an additional buffer. Exercise extreme caution when a potential partner appears young or talks about doing something characteristic of younger individuals, going to high school, etc. And document communications that clearly establish age representations. Lastly, what to do if you're facing charges. If you find yourself accused of sexual conduct with a minor after being deceived about age, follow this instructions. Do not speak to law enforcement without legal representation. We can't stress this enough. Explaining your side to the police often backfires, as your words can be used against you to strengthen the prosecution. And contact experienced legal counsel immediately, who understands the nuances of sex crimes charges and accusations. If you are in need of expert legal defense for Arizona dating app age misrepresentation charges, get in touch with our experienced attorneys today. These are an alarming intersection of fresh technology, deception, and strict liability laws. At VS Criminal Defense Attorneys, we understand the subtlety of these cases and are aware that a lot of individuals who end up in these circumstances never had any thought of defying any law. Our extensive experience of fighting such charges enables us to develop strategic plans that address the unique circumstances of each case, including exploring the narrow defenses under Arizona law and negotiating for reduced charges when appropriate. If you or someone on your behalf is being charged as a victim of a dating app scam, contact our office today to discuss your legal choices and begin building your defense. This information is provided for general information purposes only and is not legal advice. Every case has its own unique set of circumstances that need independent analysis of the law. For personalized advice tailored to your case, contact VS Criminal Defense Attorneys directly to schedule an appointment with one of our experienced criminal defense attorneys. Call us at 480-923-9001 or visit us online at vsattorney.com.
Welcome to the VS Criminal Defense Attorneys podcast, providing an informative resource on criminal law with a specific focus on sex crimes. From protecting yourself from false accusations to understanding the exact boundaries of the law, being informed is always the best first line of defense. This podcast series is reviewed and approved by attorney Michelle Villanueva Scora.